FundingInSecure, the inside story of the litigation that killed the company. Part 2, the London claim. Welcome to the second part of this series exploring the downfall of the peer-to-peer lending firm FundingSecure. In part 1, we introduced the company. We explained what it did and how it worked by allowing members of the public to collectively crowdfund loans secured against property and other assets. We introduced the directors, including Mr. Richard Luxmore, and we looked at the litigation that ultimately caused the company to collapse. This episode is an in-depth look at the London claim, which was initially filed at the High Court in June 2019. You'll recognise former director Richard Luxmore as defendant number 5. The claimant is FundingSecure. Now, the rights to this litigation was sold to a company called Acertis, a specialist commercial litigation funder following the firm's collapse. To avoid confusion though, I'll be referring to FundingSecure as the claimant throughout. The London claim has 8 defendants. 7 of them are linked and have been described in court papers as the Mark Clarkson or MC defendants. Additional claims were made against Mr. Luxmore. Unless otherwise indicated, all the defendants explicitly deny any accusation of wrongdoing. So just who is Mark Clarkson? He describes himself as a property developer and was a borrower on the FundingSecure platform. The MC defendants are also borrowers on the platform. However, Mr. Clarkson says that all of them were acting under his instruction when they obtained monies from FundingSecure. These claims are detailed in legal documents signed by then director Carl Davis on behalf of the company. So how should the platform have worked? Well, members of the public would register and place money on the platform. This money would be held in a so-called client account. This is a bank account which is supposed to be completely separate from the funds held by the business. After all, it's not the business's money. Client accounts are governed by strict FCA rules. Prospective borrowers could approach the platform with an asset, like this tasty nugget of cheese. The asset would be valued and placed on the website. Prospective investors could browse these available loans, and if they considered it was a good investment, they could pledge their money held in the client account. Once the loan had been fully funded and once the paperwork had been sorted, FundingSecure would transfer the money to the borrower and then act as a security trustee, holding the security on behalf of the investors. For actual items, FundingSecure said they'd store these items securely. For property, FundingSecure purported to register a restriction on the title deed known as a charge. This protection didn't always happen. According to the particulars of claim filed by FundingSecure, then director Richard Luxmore did not operate the platform in this way. It is said Mr. Luxmore took money from the FundingSecure client account and paid it directly to Mark Clarkson and his associates. Some of this money was sent without instruction or knowledge of the investors. They still have no idea that their money had been used in this way. Some of these advances left a £2.5 million black hole in the client account. We'll see how this was filled in later on. FundingSecure say that these payments fall into 3 categories: off-platform advances, false loan entry advances and genuine loan entry advances. It is said that the defendants were aware that the advancing of these sums involved the wrongful dissipation of funds and the creation of false and fraudulent documentation. Category 1 is said to concern so-called off-platform advances, which total £2.5 million. It's claimed that there was no loan entry on the platform, no security was taken, and no loan agreement was signed. This is an astonishing claim, as in effect it could be said that FundingSecure simply gave the money away. In response, Mr. Luxmore confirmed that certain loans had not been placed on the platform. He said that on some occasions, rather than a contractually binding agreement, the parties merely understood what the arrangement was. At any point in time, he says, FundingSecure had a number of these loans in existence, something he describes as an established practice of the company. The so-called false loan entry advances concerned some £4.3 million and were initially made in exactly the same way as the Category 1 loans, with no loan entry on the platform, no security and no loan agreement. It is said that after the money was paid to the borrower, Richard Luxmore created false and fraudulent loans on the platform in order to induce investors into unwittingly covering the shortfall in the client account. This meant the loan entry was sham, the security was sham, and the loan agreement was sham. Mr. Luxmore agrees that he did cause FundingSecure to pay monies before presenting the loan to investors on the platform. When investors did pledge money, they would have had no idea that their funds had already disappeared off the platform. Mr. Luxmore says he retrospectively recorded the loan as having been made by the lender. Again, this is described as an established practice. The Category 3 loans are said to be genuine loan entry advances, where the loan entry, the security and the agreements were all correct and valid. FundingSecure say that had they known about the first two categories of advances, they would not have permitted these amounts totalling some £1.6 million to be made. Mr. Luxmore replied that at the material times of the claims, the company was fully aware of the lending practices used by both himself and fellow director Nigel Hackett, and he seeks to draw a distinction between Category 3 funds advanced before the Category 1 and 2 loans were made. The assertion that the lending could be excused as an established practice was denied by the company. They described this excuse as embarrassing for lack of detail, concluding that what Mr. Luxmore did was fraudulent conduct, which they say would amount to a breach of FundingSecure's regulatory obligations and that it would breach the terms and conditions that exist between the lender and the platform. The company is also critical of Mr. Luxmore personally, saying that his conduct would amount to a breach of his directorial duties. So where did all the money go? It was FundingSecure's case that the funds were sent to these parties connected to Mark Clarkson and the MC defendants. The scheme was apparently concealed by sending the money to nominal borrowers to hide the fact that the payments were ultimately being made to Mr. Clarkson, and by targeting investors who they thought were less likely to conduct due diligence checks. FundingSecure referred to an email where Mr. Luxmore asked what the minimum amount of funding for a certain venture of Mr. Clarkson's would be, on the basis that larger loans attract larger investors who do their own due diligence with regards to property and client. FundingSecure say they will rely on, among other things, these 8 pieces of evidence. Responding to this evidence, Mr. Luxmore says it simply isn't fair to expect him to be able to respond to what he describes as a small and selective number of emails and communications. Some of this evidence was deployed in a private hearing in front of High Court Judge Mr. Justice Arnold. He is reported to have said it was very hard indeed to imagine an innocent explanation for the emails. It was at this hearing that the court granted a worldwide freezing injunction against both Mr. Luxmore and Mr. Clarkson. One loan that turned out to be a sham was this terrace property in Reading. A loan totalling some £195,000 was taken out in June 2017, said to be secured by a first legal charge. This was a lie. According to the title deeds, the security in the form of a charge was only registered on the property some 19 months later in January 2019, the same month Richard Luxmore left the company. This charge ultimately turned out to be defective. The mouse in the court has been shown updates given to the members of the public who invested in this loan. They were told in October 2020 that following a formal review, the documentation is insufficient to effect a recovery. The loan was closed with no funds returned. What makes this loan extraordinary is that the owner of the property is one Miss Elsa Luxmore, the wife of Richard Luxmore. She works as a parish administrator in a Roman Catholic monastery and lists management of this property on her LinkedIn page. It must be stressed, We have seen no accusations of wrongdoing against Ms. Luxmore, and we have seen no suggestions that she benefited from the £200,000 that was ultimately unrecoverable. The exact details are unclear, but we do know that by autumn 2018, the Financial Conduct Authority had begun an investigation into FundingSecure's use of the client account. Raj Kumar, who it's understood had been a customer on the platform, had become aware of this investigation. It said he agreed to lend £1.5 million to the company in order to regularise a position with the client account. He subsequently became both a director and the controlling shareholder of the company. It's claimed he bought FundingSecure for other, more nefarious reasons, resulting in legal action taken against him and others. These allegations are denied and discussed in further detail in the London counterclaim. It is common ground that a meeting took place at FundingSecure headquarters on January 2nd, 2019. Richard Luxmore says that it was proposed he should leave the company with zero compensation. He says this was described as a form of punishment for his conduct. Mr. Luxmore also says that he was told that if he gave up his shareholdings in the company, no legal action would be taken against him. Unsurprisingly, FundingSecure denies that this is what he was told. So what happened? Well, at a High Court hearing connected to this matter held in February 2021, His Honour Judge Hodge QC explained that the claims against Mr. Luxmore had been settled by a so-called Tomlin order. This is a confidential agreement between the parties. Mr. Clarkson strongly denies any accusation of wrongdoing. He says his only relationship with Mr. Luxmore was a commercial one, and he says he had no detailed knowledge about how FundingSecure operated or the source of its funds. He says that any money paid to the MC defendants were commercial loans, which are due to be repaid to FundingSecure along with interest. He doesn't deny the debt exists. Mr. Clarkson also makes a serious counterclaim, alleging that two directors of FundingSecure, along with others, entered into a £15 million conspiracy to deprive him of a property in Manchester. We'll discuss this allegation in part 4, which will look at this London counterclaim. We emailed Mr. and Mrs. Luxmore for comment. They didn't reply, so I asked them in person. Hello.
Hello.
Mr. Luxmore.
Yeah.
My name is Daniel Cloak. I'm from a website called Mouse in the Courts.
I don't have anything to say.
Okay. Would you like to apologise to the members of the public who stand to lose millions of pounds as a result of lax business practices at FundingSecure? FundingInSecure is a Mouse in the Court production. For more information about this claim, including access to the underlying court documents and to donate to the Cheese Fund to support crowdfunded journalism, please visit mouseinthecourts.co.uk.